Thank you very much. Like all the previous speakers, I'm very pleased to be here, and I'm grateful to the organizers for taking care of us so well. My topic today is, let me see how this, okay, is Robert Alexy and the dual nature of law. So it is his dual nature thesis. So I'm concerned with the question of the nature of law, not with the constitutional rights or legal interpretation. The dual nature, or the dual nature thesis is, of course, it's a large topic. So I will try to present the thesis and say a few words about conceptual preliminaries, and then I will try to comment on 4 different topics here. First, the correctness thesis, you can't avoid it. You simply cannot avoid it. Although Brian Bix has been speaking at length about it, I will have to say something. Then I will consider discourse theory, and specifically the notion of discursive possibility. After that, I will consider Alexis' argument in support of the claim that law has a real dimension in addition to the ideal dimension. And finally, if time permits, I will conclude my thoughts and raise some questions about the methodological status of Alexis' inquiry into the nature of law. Well, sorry about the hyphen here. The dual nature thesis, as I understand it, is this. Necessarily, law has both an ideal and a real dimension. And the real dimension, of course, is social efficacy, that people obey the law, and the issuance of legal norms, where the ideal dimension is a moral dimension, or essentially a moral dimension. So this is the thesis that I would like to consider. And a question here which relates to what I said about the questions of method concerns the concept of necessity. What does necessarily mean here? So as Alexis sees it now, the debate about the concept of law, the question of the nature of law, is to be understood as an analysis, the attempt to analyze the concept of law. And the debate about the concept of law, as Alexis sees it, centers on what we call the separation thesis. And this thesis is rendered as you can see here by Alexis. It's usually said that the separation thesis has it that there is no necessary connection between law and morality. Alexis puts it slightly differently, but I don't think he means to say anything different, really. He says that the concept of law is to be defined in non-moral terms. And as he points out in the beginning of his book, The Argument from Injustice, the Begriff von Geltung des Rechts in English, normative arguments will play a role in this enterprise. Alexis' conceptual framework, I should mention this. As many of you know, Alexis is careful to explain that his debate, or his contribution to the debate about the nature of law, takes place within a certain framework. So he makes some distinctions, and for example, a concept of law that embraces a concept of validity and the concept of law that doesn't. And he goes with the one that embraces a concept of validity. And furthermore, he makes a distinction between a concept of law that sees law as a system of procedures and norms, and one that sees it simply as norms. And he goes with the first one, the idea of procedures and norms. And he makes a distinction also, as is well known, between 2 different perspectives that you may adopt, the perspective of the observer and the perspective of the participant. And he focuses mainly on the perspective of the participant. And that's where he says that the separation thesis doesn't hold. It does hold within the perspective of the observer, but we're mainly concerned again with the perspective of the participant here. There are also 2 types of connection between a legal entity and the moral quality of that entity. And those are classifying connections and qualifying connections. The classifying one says that if the relevant legal or the purported legal entity suffers or lacks moral quality, so to speak, it also, as a result, lacks legal character, whereas the qualifying connection means that such an entity becomes a legally faulty entity. And then again, there is the distinction that he notes, but doesn't make so much of here, but he notes it between conceptual necessity and normative necessity, where normative necessity simply means obligatoriness. And that is quite in keeping with usual ways of looking at this. And also, well, I think I pretty much said this, that he offers two analyses of the separation thesis, one within the first perspective and one within the other. Now, the correctness thesis. Necessarily, law raises a claim to correctness, and this is a matter of conceptual necessity, and it is the correctness here is at least partly moral correctness. It's a question. One may well wonder what exactly it is, how moral correctness relates to legal correctness in a more narrow sense, but I will not go into that. And it's familiar, too, that when we're speaking of classifying and qualifying connections, Alexy makes a distinction between legal systems as a whole and the various individual legal acts. And the result, then, if you think of a legal system that doesn't raise a claim to correctness, well, then it lacks legal character. And if it does raise a claim to correctness but doesn't fulfill it, well, it's legally faulty. When we come to individual legal acts, court judgments, for example, whether such an entity doesn't raise a claim to correctness or raise a claim to correctness but doesn't meet it, well, in that case, it's legally faulty. Now, as for the actual arguments, Brian mentioned them, but I'll give them to you again. So you may say, why should I believe that law necessarily raises a claim to correctness? And the Alexis arguments here are take the shape of these two examples, a constitutional article that you can see and a court judgment. And Alexis' claim is simply that these are absurd. Intuitively, you look at them and you perceive that they're absurd. Why are they absurd? That's the question. And Alexis' answer is that they involve a performative contradiction. The idea is that the best explanation of this absurdity is that there is an implied claim to correctness whose claim to moral correctness is contradicted by what's said in these in the constitutional article and in the court judgment. Unjust specifically and incorrectly interpreted. So again, we assume that these are absurd. Some people, I don't think everyone agrees that they're absurd. So if you don't, well, the argument won't work on you. But if you do, and I'm inclined to agree with Alexy here, I think I also get a sense of absurdity. And the explanation, again, is that it is because there is an implied claim to correctness. Alexy calls this a performative contradiction. Because again, the contents of these legal entities contradict the implied claim to correctness. Now, I want to say a few words. I'm going to defend Alexy against Joseph Raz's objection, but the whole thing is a bit difficult. So, Joseph Raz, a person who needs no introduction in legal philosophy circles, he says the claim to correctness really is just a special case of a more general claim to appropriateness that is necessarily raised by anyone who performs an intentional action. Whether you're combing your hair, brushing your teeth, getting dressed, driving your car, or threatening someone, or taking your wife or husband out to dinner, there is an implied claim to appropriateness. So, and the relevance of this objection to Raz is that Alexy is putting the cart before the horse. Alexy is aiming to use the claim to correctness to elucidate the nature of law, to establish the ideal dimension. But Raz says, you can't do that because you don't know the content of this claim to correctness, which is, again, just a special case of a general claim to appropriateness. You don't know the content of this claim until you have clarified the nature of law. So again, so you can't use this the way you. And I think this is a suggestive, somehow an attractive objection that I wouldn't have thought of myself. But there are a couple of questions. First, is the appropriateness thesis true? Well, I'm not so sure. Maybe it is, maybe it isn't. These examples, do you really think we're raising a claim to appropriateness? And necessarily so, in every intentional action. If I go to the bathroom now, I don't know, that doesn't seem fully convincing to me. But I'm going to assume that Ras is right there, nevertheless. Let's say we do. Then the question is, does this undermine Alexis' position? Well, I, for one, don't think so. And this is a bit tricky, I think. But the reason why I don't agree with Ras is that I think that in invoking the correctness arguments, it seems to me that Alexy has indeed performed at least a mini inquiry into the nature of law, an inquiry the result of which is reported using the claim to correctness. So it seems to me that even if Ras is right that the claim to correctness is just a special case of a general claim to appropriateness, that doesn't, he can't take away from Alexy that he has made an effort using these two, the constitutional article and the court judgment, to elucidate the absurdity. You can of course simply say it's not absurd. Then Alexis' argument won't work. But if you agree tentatively that it is, it seems to me that, well, Alexis is going somewhere here. Maybe not all the way, but he's going somewhere, and I cannot quite see. Maybe I misunderstand Ras here, but I don't think that he is successful in trying to undermine Alexis' argument. Interestingly, I must keep track of the timer. Interestingly, Alexy, and here I must complain a little bit. Alexy responds to Ras and says that, well, there is a difference between the claim to correctness and the claim to appropriateness, namely that the claim to correctness is a claim addressed to all, it's a claim to objectivity. And that doesn't hold for the claim to appropriateness. And Alexy involves or makes use of the bandit example, a bandit threatening to do something. And Alexis says, well, in this case, the bandit is not claiming that his threat or his order to kill someone or something is morally defensible, or that everyone must accept it. And I agree with that, but I think there is a claim to objectivity, although it's simply a more limited one that doesn't have anything to do with moral acceptability or permissibility. It's simply a claim that, let's say the claim is that it's objectively true that this is an appropriate bandit action. So I think that on this, I think Alexy overshoots the mark. But I also think that it doesn't matter so much. But because I don't think that that Ras succeeds in the first place. So that's where I stand on this. And I think that's pretty much what I just said. Discourse theory. And here I simply want to say this. The question here concerns the notion of discursive possibility and its relation to the claim to correctness, and more generally to any claims of normative necessity that Alexy makes. For example, that what's involved in the argument from injustice, for example. It seems to me, this could perhaps be debated further, but it seems to me that if you argue on the one hand that law necessarily raises a claim to moral correctness, and then someone says to you, like Kelsen or Elfrost or someone would say, well, you know, moral objectivity, there is no such thing. We're non-cognitivists here. But then Alexis says, well, I have discourse theory, which will back up my claims. But if Alexy also concedes, and I think he's right in doing that, that there is not only discursive necessity and discursive impossibility, but also discursive possibility, meaning that in a discursively possible world, the relevant claim, obligatory that P, that's just a legal claim, you ought to pay your taxes or something, is discursively possible, means that the result in one possible world is that the claim is let's say, that it is the result of the discourse according to the rules. But there is also another possible, or discursively possible world, where the contradiction or the contradictory of this claim is the result, then I wonder, can you really square this with the claim to correctness, and more generally to the claim with the claim of normative necessity? If you allow, I mean, necessity here would seem to require, in my view, I mean, if you say it's normatively necessary, it seems you need to back this up with discursive necessity or discursive impossibility. You can't allow that, that the result of the discourse in some discursively possible world is the negation of the claim under consideration. It seems to me that that simply doesn't. This is a so there's a problem with the foundation of this. Of the claim to correctness here, if I'm right. I agree that this is not crystal clear, but it seems to me that Alexy is conceding, I think he's right in conceding that discourse theory can't generate discursive necessity or impossibility in all cases, that there has to be discursive possibility. But if you admit that, can you consistently maintain that the idea of a claim to moral correctness? Well, I doubt it. Okay. Now we have the real dimension. I find this intriguing because if Alexy is successful so far, he's established a law's ideal dimension. We've seen that. Now he's after the real dimension, which if we start out with the real the ideal dimension, Alexis' argument is that law needs a real part in order to avoid the costs of anarchy and civil war and to achieve the advantages of social coordination and cooperation. Well, what is the status? How does this argument look? And here I have taken the liberty. Oh my God, can't you even? You can't even see the man. I don't know how to operate this. I would like, the number 8 is the conclusion, but now you can't see it. I don't understand how this. Does anyone? I would like to squeeze. So Marlene, can you make this so we see it all?
Maybe if it just get out of here for a second. And maybe we can make it a bit smaller.
Oh.
In my computer it was also okay.
Yeah.
But it depends probably.
Yes, let's make it a little smaller.
Let's check now. I hope it works. So?
Yes.
Here.
Yes. Yeah, I have it here. Right. Wonderful, thank you so much. Well, this is, it gets perhaps difficult to see, you know, and it doesn't, I need it to look proper at least, you know, otherwise it'll be confused. So what I'm doing here, I'm pointing to 4 different premises, and then I do some very basic derivations here and arrive at number 8, which is the conclusion. So the first premise here, I hope I can, now, the first premise, it says, the box then means necessary. So necessary C. So it's conceptually necessary that C. It's conceptually necessary that law raises a claim to correctness. Then I've added a second premise, which says that it's normatively necessary that if law raises a claim to correctness, then the claim to correctness is satisfied. Then we have premise 3, which says it's naturally necessary, necessary in keeping with the laws of nature, that if you have anarchy and civil war, the claim to correctness will not be satisfied. Number 4 says it's naturally necessary that if you don't have a real dimension, you will have a situation of anarchy and civil war. And then you take 1 and 2, and you get that it's normatively necessary, again, obligatory, that that the claim to correctness is satisfied. You take 3 and 4 together, and you get 6. It's naturally necessary that if there is no real dimension, there is no, the claim to correctness will not be satisfied. You turn this around, you go from 6 to 7, that's contraposition simply. So it's naturally necessary that if the claim to correctness is satisfied, you have a real dimension. And then you take 5 in conjunction with 7 and you get 8. That is normatively necessary that law has a real dimension. Now this deserves, of course, a little more discussion, but the point here is that you see the box, it indicates necessity, but you see that I've qualified the box in various ways, which means that, and that matters, because the conclusion is 8, is what Alexy wants to arrive at, and that is normative necessity, obligatoriness. But this argument then is a problem. My problem with this is that I think that Alexy would need a stronger conclusion, one framed in terms of conceptual necessity, given that he is concerned with the analysis of the concept of law. Now, Alexy is aware what he's doing. I'm not saying that he is not aware of what he's doing, but I'm bringing out, well, certain tensions, I think, in his argument. And let me just say this. Problems with the argument. 1, the conclusion is too weak. I just said that. Can premise 2 be justified at all? This is premise 2. I added this. I don't really see it in Alexis' reasoning, but it's needed. If you don't have this premise, you're not going anywhere here. So I added it. But it's not clear that it can be justified. And that's a problem. Maybe it can be, but it's not clear to me how. Now, premises 3 and 4, I say here, are really factual claims, not claims of necessity at all. This is that if you have a situation of anarchy, claim to correctness will not be satisfied. If you don't have a real dimension, there will be those are not necessary claims, it seems to me, but rather perhaps factual claims, perhaps claims of probability or something. You could also ask number 4 here, does a situation of anarchy really mean that the claim to correctness cannot be satisfied? That is premise 3. So these are my complaints about the arguments. And I will conclude now, having complained and complained, except agreeing with Alexy on one point. What I want to say now is that these things about types of necessity are important, it seems to me, because the question ultimately is, what is Alexy trying to do? And Alexy, as I understand him, thinks of an inquiry into the nature of law, which is clearly what he's concerned with, as a matter of analyzing the concept of law. And so thinks Joseph Raz, for example. That is, I think, perfectly fine. But then, what one is after is conceptual necessity. It's to be in the concept, it's part of the concept of law that, let's say, that it has a real and an ideal dimension. If it is, then it's in the nature of law. It is necessarily the case, conceptually necessarily the case, that law has a real and an ideal dimension. So I'm a bit worried about Alexis' moral arguments, the normative arguments. What are they doing in this? If you bring them in, are you really analyzing the concept of law? Now, I don't think Alexy would have said so. I'm suggesting here, maybe he's trying to explicate the concept of law. I don't think he is, because he would have said so, because he knows very well what that is, but he doesn't say that he's doing that. But the reason why I'm considering this possibility is that I think that, well, perhaps then you can twist things a little, or tweak things a little bit, so that you can use moral arguments. But I don't think that would work either. So this is what an explication in the sense of Carnap is. You begin with a concept, with an idea, discrimination, legal rights, law, what have you. That is intuitively clear, but not so sharp, not so well defined. And for scientific purposes, you want to clarify this concept without changing it too much. So you want then similarity between the explicandum and the explicatum. Here, the explicandum is what you start with, and the explicatum is what you arrive at. You also want exactness, fruitfulness, and simplicity. These are not moral requirements, it seems to me. But what about you need a purpose. You explicate for a purpose. And Alexy does distinguish, as we've seen, between the perspective of the participant and the perspective of the observer. Now, one could, I'm I'm speculating here, as Ralph said that he was. I don't think Alexy is doing this, but he could be. So then I could say that maybe Alexy is explicating the concept of law within the perspective of the participant. And if so, this is what it would look like. This would be the same thing, although it will be done here within the framework of the observer. But then I would say these two purposes are not moral purposes. The idea here was to say that if the purpose is moral, maybe you can say that the criteria of a successful explication receive a moral content somehow. I don't think so anyway. But anyway, these are not moral purposes. So what I conclude is that moral arguments are of doubtful validity in the enterprise of explication. And they are certainly of doubtful validity in the enterprise of analyzing in the more strict sense. We have something we call normative positivism. Normative positivists like Jeremy Waldron and Tom Campbell and perhaps others think that the debate about the concept of law cannot be fruitfully conducted on conceptual grounds. You're going nowhere, they say. You need to argue morally all the way down, so to speak, because otherwise there is no other way of doing it. Now, Alexy, of course, is not saying that he's doing this. So I'm saying, is he joining them? I don't think so. But that would be a way of justifying the use of moral arguments in the analysis. So my complaint, you could say, I could summarize my position and say something like this. Alexy aims to analyze the concept of law as I understand him, and by doing that he aims to clarify the nature of law. But he is using, and he is quite aware of this, he is using moral arguments, specifically in the argument from injustice. He says, for example, that the separation thesis is not conceptually impossible, and it's not conceptually necessary. Its rejection, I think he wants to say, within the framework of the participant, is normatively necessary. But my question is, normative necessity is obligatoriness, moral obligatoriness here. And my question is, well, does that really have a place in a legal scientific inquiry? And I don't think it does, but I'm not sure how Alexy himself sees this. So these are my conclusion is of a methodological nature. I would say it seems to me that Alexy's analysis doesn't live up to his own methodological standards, as I understand them. I could have misunderstood them, of course, but I take him to be doing one thing, analyzing the concept of law. But I see that he's making use of arguments and considerations that I can't see they have a place in the enterprise that he purports to be engaged in. So that is my overall complaint. But I share my colleague's view here that Alexy is certainly a first-rate thinker, and as they say, to be criticized is to be taken seriously. It may sound strange to younger people who are not in the business, but there is a good bit of truth in it. To criticize someone is to take him or her seriously, and that is, to many of us, a compliment, actually. Thank you so much.